My name is Gaetinger Villariash. I'm a partner in Warner's Appellate and Supreme Court Practice Group and its Real Estate Litigation Practice Group. I focus a substantial part of my practice on administrative appeals. I'm going to talk today about obtaining recreational marijuana licenses from local governments and about the competitive process that's associated with getting those licenses. Given the stiff competition out there, it's really important to understand the application process and to know your rights if there is a problem with the result. We're going to talk in particular about the selection criteria the municipalities use when they select applicants. I will talk about the scoring process and what you can expect, and I'll explain the various legal actions that can be taken if there is a problem with the result and the strategic choices that you might have to make when that happens. Let's talk first about the selection criteria in the application. Municipalities can't impose just any criteria they want when they're selecting applicants. It has to comply with Michigan law, in particular the Michigan Regulation and Taxation of Marijuana Act, also known as MRTMA. What that act requires in particular is that the criteria in the competitive process be intended to select the applicants best suited to comply with MRTMA within the municipality. Now that said, this leaves municipalities a lot of discretion in what criteria to use, so you're going to see a lot of variation from one local government to another. And those criteria aren't necessarily going to be black and white, they can be subjective. The gray area is going to give the municipality some discretion in how they score the applications. For that reason, it's going to be important that you not only try to satisfy the criteria as you understand them in the ordinance, but that you try to exceed expectations for the municipality. The more your project fulfills the underlying policies and objectives that you see in those criteria, the more likely your application is going to be one selected for the license. On top of that, it can't hurt to provide some perks to the municipality. This can be anything from restoring a dilapidated building, making it LEED certified, providing some green space, providing additional parking that maybe the public can have access to. Anything that could provide an additional benefit to the community could give your application an edge in the licensing process. So let's talk about the scoring process now. This process is unlike the process that a local government normally uses when it makes a decision. It's going to be a decision made by one person behind closed doors. It might be a clerk, it might be the zoning administrator, but they are not required to comply with the Open Meetings Act. It's lawful for them to do this without any oversight and without the public being present. You are entitled to receive your score at the close of that process and to receive the score of the other applicants. But some people interpret MRTMA as saying that you aren't entitled to request information on the application materials that were submitted by other applicants. And of course, the problem with that is that you're now going to have a hard time determining whether other applicants were scored correctly. You can figure out whether you were scored correctly because you have your application materials in the score. So you can challenge that scoring, but challenge the scoring for someone else whose applications you don't have would be practically impossible. Unfortunately, that means that you might have to start the legal action in order to get the information that you need to determine whether you have a basis for complaining. So one way to challenge the decision is to file a timely appeal. And it's important that you appeal not only the scoring of your own application, but also the scoring of other applicants who did receive a license. Now, you have to check the ordinance because sometimes that first appeal has to be filed with a body within the local government. And you have to exhaust all appeals available within the local government before you can take your appeal to circuit court. If you do have to appeal to a local government body, there's a strong likelihood you're going to find that the rules for that appeal are very underdeveloped or there aren't any at all. So it's very important that you hire someone who's well-versed in administrative law and the appellate process, because that person really needs to know how the process should work so that they can make sure to protect your rights to proper process at that stage of the appeal. Another way to challenge the result is to challenge the ordinance to govern the process. If the ordinance doesn't comply with MRTMA, that is, it does not select applicants best suited to comply with MRTMA, then the process and all the licenses that were granted under it are subject to being invalidated. Now, only a court can invalidate an ordinance. So if you're challenging the process in this way, the first step is going to be to file a complaint in circuit court. There are important strategic differences between these two ways of challenging the result. In an appeal, you have the opportunity of winning a permit through that process. But if you file a complaint against the ordinance, you don't win a permit, you win a do-over if you succeed. The municipality is going to have to revamp their ordinance to make it comply with MRTMA, and every applicant who received a license and those that didn't is going to have another opportunity to compete with you for the licenses. You need to think through the consequences before you select one or both of these ways of challenging the result. This process can be really difficult to navigate. My partners and I can help you with that.